using one dominant position, try to enter into the other segment and start putting a pressure zone altogether. The manner of assessment by the CCI. Very, very important. The Section 27 of the Competition Act provides ample room for putting in penalties in the cases of anti-competitive agreements, which we know the abuses of dominance. We don't have a proper calculation to go back and tell that this is the amount CCI will be charging for every company in India or for that companies who are making that mistake. Good morning and welcome to the session 5 in Unit 5 Commercial Law, where we are going to talk about the abusive conduct in Competition Act of 2002. Now, the Competition Act sets out the types of conduct that will be considered to be abusive if carried out by an dominant enterprise. Now, what is that considered to be abusive? Now, what happens here is that most of the people will try to dominate because that is the essence of business. You cannot rule out the business by saying that, sir, I will just take it off. No, by default, you are going to create some dominance, no doubt about it. But then, how are you going to manage this? That comes in very, very important. So in that sense, in that context, when I'm going to talk, I'm going to make you understand about this dominant enterprise factor. These include imposing unfair or discriminatory conditions or prices in the purchase of sale of goods and services. So importantly, imposing unfair or discriminatory. Suppose you are going to play with the price. Unfair prices. You try to dominate by putting it either extremely low or extremely high, trying to hurt the consumer sentiments through the pricing scenario. Yes, this is definitely going to call in for trouble. At that point of time, definitely the market is going to give a signal that, you are trying to become dominant, and the Competent Commission of India, the Competition Commission, will say definitely that though not even being dominant, but you are now creating an abusive scenario. The second thing, limiting production and supply of goods, which is very, very important. Why? Because at the end of the day, it's demand and supply that's going to play in the market. Now, you know that if you can choke the supply, choke the production of the goods itself, or the technical development that takes place behind it. So what happens here is that the access to market gets completely truncated. So now what you are trying to do, you are going to supply, you're going to hit on the mainstreams itself, which would definitely cause a problem, and that is an abusive behavior again. Using dominance in one relevant market to enter into or protect another relevant market. Because I am strong in real estate, construction business, I use it in terms of the other market, that is in commercial property development or in governmental development projects and other factors. So what I'm trying to do, using one dominant position, try to enter into the other segment and start putting a pressure zone altogether. So that will also put me in a different situation. That would be definitely called as an abusive behavior here, followed by. However, the Competition Commission Act does not provide guidance on what constitutes an unfair discriminatory price, which is very, very important, and how will certain conduct result in the denial of market services. Now, the pricing again is a complicated topic altogether. Why? Because whenever you talk about pricing, whenever you start talking about the pricing factors altogether, there is this question mark which I would always like to raise about. Why? Because what is that exact pricing are you talking about? By selling something at less than 5 rupees, or making something go at 10 rupees, or making something come down the value, what is the discriminatory pricing that you are using altogether? That is very, very important for all of us to understand and take it forward, because discriminatory price is not being told completely. Discriminatory price has only been explained, but what exactly, how the price is coming into picture, where we have to look about it, that has not been told. So when certain conduct will result in the denial of market access, so automatically the market access is not going to come into picture, it is not going to be taken into picture. So that is also going to be a very, very important factor here. The general scheme of Competition Act is based on whether certain agreements or conduct costs are likely to cause an appreciable adverse effect on competition of India. So now, for example, there might be certain practices, there might be certain agreements which are made by these companies altogether, which might lead into an abusive scenario altogether. Now that is not accepted, that is not wanted, or that might not go well with this sector. So what we try to do, we try to tell very clearly here that we will not be going in place of that. We don't want that system to come in place at all. So we are not in this position. We don't want to take that dominance effect coming into picture. So one would assume that there must be an assessment of possible pro and anti-competitive outcomes. So you need to assess, you need to find out very clearly what are the challenges, where exactly are we talking about this. Because if we are going to talk and we are going to say that these are the factors on which things are going, these are the levels of the abusive conduct or factors here, one would like to look into the assessment altogether. You will not be able to just go in and question, say that this is exactly done, this is what we are talking about. No. So we want to understand, we want to evaluate the position thoroughly and then take it up. So definitely this is going to be a question that is going to come into factor. Followed by the CCI's finding in the NSE decision focused on the effect of NSE's zero pricing policy, which would have on competitors, for example, the MCX, which did not appear take into account the perceived benefits of the customer who benefit from that reduced prices. What was CCI actually trying to do here was only trying to find out a dominant position or the sectoral factor altogether, but CCI was never able to come forward and understand the impact of the prices, the reduced prices effect. This led to finding a zero pricing being an unfair pricing under section 4 of 2. So suppose you have used the methodology or the technology of zero pricing, which is considered to be dangerous. Definitely. Why? Because using that zero pricing, you have created an dominant market and also gone to the abusive level factors altogether. So this would be considered to be bad. This would be considered to be on the negative stance altogether. Followed by, in the DLF decision, the CCI examined the contents of apartment buyers agreement. Now that was very, very important, which was executed between the DLF and the prospective buyers. Now what happens here is that the CCI was able to find out, examine the contents, and they were able to find out what happened between the DLF and the prospective buyers. The CCI declared that the agreement extremely was one-sided. Why? The finding of abuse was primarily based on the apparent relationship between the service provider and the clients. Because DLF had gone beyond the books, beyond the marketing scenario to promise its client that we are the only premium service provider. We will provide you the whatever you ask. We will even try to bring you the sky and moon to you all together. And they had gone ahead and created such a kind of position, such a kind of bargaining situation with the customers that the customers had to go in for that. So they created a dominant position in the luxury high-end market, that is the apartments market altogether. Followed by, the commission neglected how to explain that one-sided agreement itself is anti-competitive. So other side, if you have to look into it, how is the agreement being one-sided is also coming under the question mark. Can this itself become an anti-competitive matter? Now that's under question. Contrary to the NSE decision, the CCI chose a greater emphasis on the unfair terms and means that was used in the agreement while ignoring the potential the foreclosure effects of the market. So what we are trying to look into here is the unfairness of the terms. Whatever terms and conditions that are going to be put there, that will have a definitive effect, that will have a definitive policy factor in terms of the terms, policies that have been spoken about, that will have some value, that will have some effect on the consumer. That's what we are going to look, that's what we are going to judge altogether. So we are not going to let it to be done just by the pricing factor, but we are going to look in terms of whatever might be the cost factor, whatever the effects of foreclosure in the markets altogether. Followed by the Kapoor Glass decision case, very, very important, which provides the manner of assessment by the CCI. Very, very important. Why? Because this case was dealt with discounts and rebates offered by the Scott Glass to manufacturers of the glass amorphules further down to the supply chain. The Kapoor Glass company, they had taken the complete domination of manufacturing the shot glass, which was there on the Prestige, the gas appliances altogether, where they took the complete dominant position of manufacturing it and supplying it down, and they control the entire supply chain altogether. Now, this is a dominant position factor. Most of the time in the business, what becomes really important is that how you are able to control the entire chain. That is the supply to that of the factors in terms of the target, the loyalty factors and everything. That becomes a very, very important factor. So we look into this. So this is where it becomes very, very important for us as a case study to understand for the Competition Commission of India, questioning again and again, where is that we are trying to create ourselves into an abusive position. Followed by, interestingly, the Competition Commission of India did not find discounts themselves to the anti-competitive, but rather to the manner of their application. Scott chose to favor its downstream operation itself. Now, what happens here is that the way you operate itself becomes a question mark. Now, one side being dominant is what the market is telling about you, but the way you operate makes it even more obvious, even more, visualized, straightforward, stating that you want to completely hit others out of the market. You want to remain there in a position and continue doing the same aspect again and again, and you don't want to give chance to anybody else. So that would definitely form a very big dominant factor altogether. So that is definitely going to be an important factor here. Now, the absence of uniformity in application was also held to the price application. Now, we are going to talk about this also. Now, this cannot be considered to be the same in all the markets. Now, that's also another problem here. Moment we start talking about competition, not every competition is the same. Not every methodology that's applied to win over a competition also remains the same. What becomes interesting, what becomes really more dominant to talk about is that every case, there is some sort of unfair practice that has been, taken about in the market. So now CCI became even more conscious about the factor, how should I apply my brain, how should I apply my ideology in terms of dealing case-to-case basis. In certain cases, is it only the pricing? In certain cases, are you trying to attack the entire supply? In certain cases, are you trying to get into the complete factor disruption of market? Are you trying to create an abusive factor altogether? What is that you are trying to do? Where is that it's going to get across altogether? So all those factors come into picture here very clearly. Followed by the cases involving the allegations of abuses of dominance are complex in nature and involve considerable amount of economic analysis, define the market and extent of abuse. So far the cases reveal only the need for CCI to look into a closer approach. Whenever you say somebody is dominant, now let's take Samsung, which is very, very dominant in the Indian mobile market. Now, it doesn't mean that Samsung wants to be a monopoly. Equally, there is MI, Redmi, Apple, or probably Nokia, or there are even other players who are coming up in their own ways. But what happens when we talk about Samsung is that Samsung has got a pretty much closer pricing. It has got a very clear advertising. It has got a very close reach altogether. And it has got a very good relationship with its retailers and the chains altogether, where it tries to bring in its products much more prior to the other people. But that cannot be considered to be the only reason and charge Samsung saying that he is trying to become abusive in the market. What we have to analysis is that to start looking here is how much is Samsung creating an economic impact to the scenario? Is it that only Samsung is doing it or everybody is trying to jump? Or is it that Samsung has got some sort of assessment, how they are defining the markets, how they want to launch in their flagship phone, the non-flagship phone, what are the factors under which they are operating? So when you start analyzing this and start doing it, you will start seeing that there are different factors, there are different levels which have to be looked in depth completely before analyzing and before concluding altogether. So that has to be clearly revealed here. That has to be looked by the CCI before coming to a concluding factor. Now, equally, CCI will also need to consider the role of economic evidence in assessing dominance and establish clear rules when the conduct of the dominant enterprise becomes abusive. Now, this is very, very important for all of us to understand. Let's have a look into this. CCI will have to consider the role of economic evidence in assessing dominance and establish clear rules when the conduct of dominant enterprises become abusive. Now, what are we trying to say by this factor? Now, there are factors at which CCI has to bring in certain amount of evidence by saying that this is what they are doing, this is what I mean by a mistake, this is what I exactly mean by a dominant position. You cannot say everybody is dominant, because everybody will try to become dominant, everybody will try to hold the business for some factor. Nobody is going to let loose their market. Nobody is going to come back and say that, yes, I have an open-minded enough to give away my market share. After all, companies have spent years of time in gathering that market share. So when you talk about a Hyundai or a Maruti or a DLF or a Kapoor Glass, or you're going to talk about Bisleri or Parle-G or any of those kind of companies, they are not just becoming dominant. They are not just abusive in nature. They are trying to hold the market share for so long years. And why is it? Because there is certain amount of factors. So when CCI is going to say somebody that you are abusive, you are trying to beat the market, you are trying to hold the market, choke it all together, there needs to be a valid reason. Unless and until this cannot come into picture. Followed by India's newest market regulator, the CCI must be able to limit adverse multilateral conduct without damaging the competitive vigor. Now, if you start getting too much in terms of interference with the market, trying to hold everybody, trying to tell everybody, do not compete, do not be this, do not do that, do not enter into this kind of agreement, the competitive spirit goes away. People feel that this market is too regulated, too tight. I should not even enter this market. There's no scope. Why? Because every time I will be pulled up by the CCI asking 1001 questions. So I don't want to remain in this market anymore. So this is why CCI also needs to limit its activities so that they don't try and go to damage the entire economic impact or the growth factors. Followed by the penalties. The Section 27 of the Competition Act provides ample room for putting in penalties in the cases of anti-competitive agreements, which we know the abuses of dominance. The fines can extend up to 10% of the average turnover, which is very much agreed upon on the last 3 preceding financial years, as we have discussed, depending on the factors of the cases. So they can go up to the level of charging up the finances, charging up the penalties. And past events have also shown that CCI has not been shy in making use of these power. CCI has never been a system which has worried about the economic impacts or the other factor. Moment CCI feels that this is the opportunity, they have seized on it, they have gone on that, and they have punished the companies which have gone on the anti-competitive segment itself. So it is the rule of CCI to see that moment there is an anti-competitive agreement coming into India, they will show the power, they will call up the necessary parties, and there will be a penalty for that. Followed by the cement division ended up with CCI imposing a fine of 63 billion on 11 cement manufacturing companies and INR worth of 7.3 million on the CMI, the Cement Manufacturing Association of India, because that was a very big factor altogether. That was one sector which was predominantly dominated. A cartelism was there. In the DLF decision, the abuses of dominance cases won against a real estate developer, DLF, and the National Stock Exchange resulted in fines of 6.3 billion and INR of 555 million. Now look at the amount that has been connected as penalty by the CCI. So at any point of time, CCI is not going to show leniency. CCI is not going to say a soft corner. Moment it finds that yes, there is something going wrong, it is going to pick up the company, it is going to pick up the sector, and whatever might be the fine, CCI is going to take it. So the companies have to be careful. They cannot take things for granted, and they cannot just go on with a monopolizing factor anymore. Now, in several cases, penalties have been ranging from 5 to 10% of the turnover of the 3 preceding years. Despite this, it is unclear how CCI arrives exactly at the fines. The accompanying language generally alludes from the fact, or it might not shed out into the direct details altogether. Though people know that the fine will range anywhere between 5 to 10%, but still, we don't have a proper calculation to go back and tell that this is the amount CCI will be charging for every company in India, or for that companies who are making that mistake. So what happens, still there needs to be some sort of understanding, clarity in terms of the penalties that are being collected. Now, since there are no formal guidelines in this factor, CCI is effectively approaching a closed door approach, where I mean to say that it will go case by case. We will maintain all the confidentiality in terms of the particular factors. We don't want to just give it, and we will use a reasonable exercise of discretionary powers. Without objective and transparent parameters for calculation of fines, it is also possible that higher penalties might be struck down by the compact. So we are not going to give it just like that. CCI is maintaining a complete, secrecy in terms of charging. They don't want to just give it away. They feel that at some point of time, the calculation and other perspective, let it remain for themselves. We will decide it on a case-by-case basis, and we will go on this factor. Now, in addition to that, CCI General Regulations Rules of 2009 allow the parties to present submissions on the quantum of penalty before a determination of the guilt. So they give a chance to the company stating that in case the mistake, whatever you have done, we are giving you a chance, we are giving you a factor that these are the things that has happened. So we will give you an opportunity in terms of understanding, take a chance, we will go through it, we'll understand your case, and then we will fix the penalty here. When CCI takes a strong stand against the contraventions of Competitive Act, both the decisions and the level of fines, industries and other stakeholders are waiting for a greater transparency regarding the calculation. Yes, of course, the industries and the stakeholder people want to understand CCI from a transparent position altogether, and that's what is the most expected thing from the CCI to come forward. With this, I come to the end of this particular session. I hope and believe that all the information shared here would be of a great value and resource to you. In the upcoming sessions, we shall learn more about the Competition Act and its features. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.